Under the common law, a lessee's covenant to return the premises in substantially the same condition as it was received required the lessee to repair the premises if it was significantly damaged or destroyed for any reason. But does this rule still apply today? The Minnesota Court of Appeals considered this question in the case of Amoco Oil versus Jones. From 1968 to 1985, Llewellan Jones leased a gas station in Minnesota from Amoco Oil Company. Under the lease agreement, Jones was required to keep the premises in good repair. Further, upon termination, Jones had to surrender the premises in substantially as good of a condition as when he received it, except ordinary wear and tear. The lease didn't provide which party was responsible for maintaining fire insurance. Also, the lease stated that Amoco could terminate or choose not to renew the lease under various circumstances, including the destruction of all or a substantial part of the premises. On Christmas Eve of 1985, a fire broke out at the gas station, which caused substantial damage to its structure, but neither party was negligent or at fault for causing the fire. Following the fire, Amoco terminated the lease based on the destruction of all or a substantial part of the premises. Amoco then sued Jones in state district court for breach of the lease and argued that Jones failed to return the gas station in as good of a condition as when he received it. Following trial, the court directed a verdict for Jones, finding that he didn't breach the lease because the lease's terms didn't contain a covenant to restore the property to its original condition in the event of severe destruction or damage. Amoco appealed to the Minnesota Court of Appeals.